President Lachs, with Honorable Justices Rindskopf and Charney presiding.
Be seated.
Case before the court is the matter of Leonia versus Vulpinia. The applicant and respondent are each allotted 45 minutes.
The hearing is open. The court meets today to consider the case between Leonia and Vulpinia. Both parties submitted to the court their memorials in the time limit fixed by the court, and the hearing takes place after the lapse of the time limit agreed with the parties. I notice the presence in the court of agents and counsel or co-agents of both Leonia and Vulpinia. We shall hear both parties pleading their case, but before I proceed to this, the court will take note of the provisions of Article 63 of the statute of the court, which lays down that in any case in which a construction of a convention to which states other than those concerned in the case are parties in the question, the registrar shall notify all such states forthwith. On the instructions of this court, the registrar did notify all parties to the Antarctic Treaty, but none of them responded. Thus, we have the two parties pleading before the court. The court will first hear the agent or co-agent of Leonia. Please, you have the floor.
May it please the court. My name is Myra Creighton. My co-agent is Mike Sharp, and we represent the state of Leonia. Today I will show this court first that Vulpinia violated a treaty between itself and Leonia, and second, that it violated customary international law when it discharged hazardous waste into the Antarctic seas and exterminated an entire species of marine life. In early 1987, a Vulpinian hazardous waste expert was having difficulty servicing his clients. He decided to experiment and placed 100 drums of hazardous waste on the Stella Maris ice shelf. Leonia observed the placement via satellite, confirmed the contents of the drums, and then contacted Vulpinia and requested that the drums be removed. In an exchange of notes dated February 2nd, 1988, Vulpinia explicitly agreed to remove the 100 drums of waste and restore the Antarctic Treaty area to its pre-existing condition. However, in direct violation of both the treaty and customary international law, Vulpinia discharged 5 drums containing an extremely explosive and corrosive waste into the Antarctic seas and eradicated a unique species of starfish. Today, this court is confronted with a compelling issue of environmental law. First, Vulpinia is responsible for a breach of right pertaining to Leonia because it violated the express terms of the exchange of notes dated February 2nd, 1988. The exchange of notes was a treaty. It was registered pursuant to Article 102 of the United Nations Charter, which says that every treaty shall be registered with the United Nations, and thus Leonia may come before this court and seek redress for the breach of that treaty. Vulpinia did not carry out its obligations under this treaty in good faith, did not adequately prepare for the removal of the drums. When Vulpinia was contacted to remove these drums, it agreed to remove the drums and then contacted Dr. Detritus, the expert who had placed the drums on the Stella Maris ice shelf, and requested that he act for them in finding a way to remove these drums. In its discussions on state responsibility, the International Law Commission has stated that when a person or group of persons undertake to act or carry out obligations on behalf of a state, then if they cause damage, the state is responsible. Thus, the failure of Dr. Detritus to adequately prepare for the removal of these drums should be imputed to Vulpinia, and thus Vulpinia should be responsible for a breach of right pertaining to Leonia. Dr. Detritus is a hazardous waste expert. He knew the contents that were in those drums. He knew the chemical composition of the drums and the pressure that he had placed that waste at. Thus, he should have known that the drums would corrode. It is reasonable inference from the compromise that the only alternative that Dr. Detritus provided, aside from being able to take those drums off the shelf intact, was to discharge them into the Antarctic seas. His team of technicians on the ship told the Leonian observers that after 10 days, that the water would be restored to its previous purity and salinity. However, there is no indication that Dr. Detritus made any effort to ascertain the effects of those wastes on the marine life in the area. The marine life in Antarctica is of a high degree of specialization given the harsh climatic conditions in the area. It is completely foreseeable that the discharge of those wastes would cause hazards to all the marine life in the area, and the harm that was carried out is the harm that was completely foreseeable, that marine life would be damaged. An entire species has been lost because Dr. Detritus, in the 11 months he had to prepare for this expedition, did not do so in an adequate or reasonable manner.
Counsel, I've heard you describe the events that have taken place, but it's not clear to me how your state has standing to bring this claim and how it may be an injured state in that regard. Could you explain that?
Your Honor, first of all, Leonia has standing because it is the immediate party to a treaty that has been breached between the two countries. And secondly, it has standing as a consultative party of the Antarctic Treaty, which Leonia contends is customary international law. And under Article 10 of the treaty, they are given the right to pursue any violations of the provisions or the purposes of the treaty. Clearly, the discharge of this waste violated the implicit provisions of the treaty that the environment of Antarctica should be protected.
But how could a treaty to which a state is not a party establish any duties with respect to that non-party state?
Your Honor, when a treaty's provisions have become customary international law, that state is obligated. Under Article 38 of the Vienna Convention on the Law of Treaties, which both Leonia and Vulpinia have ratified, it states that Articles 34 through 37, which deal with a state, no obligations for a third-party state or require the assent of a state, that those provisions of the treaty in no way detract from a state's responsibility or obligation when a provision of a treaty has become customary international law.
So you're proceeding not on the basis of the Antarctic Treaty, but on the basis of customary international law. You're stating that customary international law gives your state standing to bring the claim and creates an injury to your state.
Yes, Your Honor. However, in addition, when the consultative parties were informed of the damage that was done, the chair of the party, which the consultative parties met, issued a joint communique which said that those responsible should take care of the situation. And thus the consultative parties of the Antarctic Treaty implicitly authorized Leonia to act as their agent in this proceeding, given the fact that they were the immediate party to a treaty that had been breached and were carrying out their obligations as a consultative party and a protector of the marine environment in Antarctica.
But what is then the relationship between the treaty, the Antarctic Treaty, and customary law on which you rely?
Your Honor, the provisions of the treaty have become customary international law.
But your entitlement is derived from the treaty.
Your Honor, it is derived from Article 10 of the treaty, which states that all...
Well, then you rely on the treaty too.
Yes, Your Honor. Both the treaty...
What's the relationship between the two?
Your Honor, I'm not sure if I understand your question.
What's the relationship of your local standi before this court on the Antarctic Treaty or on customary law, or on both?
Your Honor, Leonia contends that the Antarctic Treaty is customary international law, including Article 10, which gives them the right to pursue violators. And the joint communique implicitly authorizes them to act as the agent for the consultative parties in this proceeding. So they have standing before this court, in addition to their standing because of the breach of the treaty between the two countries.
But it's not clear to me how the consultative parties to the treaty can grant standing to your state vis-a-vis a state that is not a party to the treaty. How has this organization, if it is an organization, obtained any rights vis-a-vis non-state parties or duties?
Your Honor, Leonia would contend that the Antarctic area is the common heritage of mankind, and they would contend that...
What did you say? It's the common heritage of mankind?
Yes, Your Honor.
Is it?
Yes, Your Honor, and my co-agent, Mike Sharp, will discuss that and show that before this court, that it is the common heritage of mankind.
So it will be on his burden, not on yours, to prove.
Yes, Your Honor.
All right.
May I interject here with a different question? What are the facts that you're saying give rise to this claim? Is it the original placement of the drums, in Antarctica, or is it the removal?
Your Honor, it is primarily the removal, because when Leonia contacted Vulpinia and requested that the drums be removed, Vulpinia did act in good faith in agreeing to remove those drums.
Well, if it's the removal, isn't there an emergency exception? Do we really have an act of dumping here? What was their alternative?
Your Honor, the alternative was that they could have left the area and then come back, or they could have taken extra drums with them. The International Court, excuse me, Your Honor, the International Law Commission has stated in its discussions on state responsibility that a state may not create its own defense, and that is precisely what happened in this situation. By its failure to adequately prepare, Vulpinia has created its own defense, given that Dr. Detritus knew the chemical contents of those drums, and that he knew the chemical composition of the drums. And
But our statements of the International Law Commission law?
No, Your Honor, but they would come under Article 38 of this court, Article 38, which says this court may rely on respected publicists. And in addition, this court has previously indicated that it is very important, and in fact, the International Law Commission should be recorded the greatest respect by this court because of the international nature of the Law Commission and the well-respected publicists that sit on it. And that was in Judge Jessup's dissent in the Southwest Africa cases that he stated that.
Yeah, he said it in his opinion, in his dissenting opinion. That's right.
Yes, Your Honor, but in addition, both Perry and Brownlee have stated that the International Law Commission
But not as a source of law.
No, Your Honor, is it a subsidiary means that this court may rely on under Article 38?
But you should rely on substantive law as such. What is the basis of substantive law?
Your Honor, first, that they violated the express terms of the treaty, which stated that that Vulpinia shall remove the 100 drums of waste to restore the Antarctic Treaty area to its pre-existing condition. They did not do that. They discharged 5 drums into the most vulnerable ecosystem in the entire world and eradicated an entire species of marine life that can never be brought forth again. In addition to violating this treaty, Vulpinia has violated customary international law that is found in the 1982 United Nations Convention on the Law of the Sea and in the Antarctic Treaty. This court stated in the North Sea shelf cases that in ascertaining whether or not a provision has become customary law, there are 4 criteria. First,
Before you get into that, you say that they violated their duty to restore the status quo by discharging the substance which destroyed a species, but as far as we know, they were not aware that this species existed. What kind of duty do they have in this regard? Is it a strict responsibility, or is it something less than that?
Your Honor, Leonia would contend that Vulpinia acted negligently in preparing for this expedition of retrieval. However, if this court should find that that is not the case, as my co-agent will adequately outline and show this court, they should be held strictly liable for a substantial harm to the environment.
Even though it was not foreseeable?
Your Honor, this harm was completely foreseeable.
But that's for the co-agent to argue.
I assume she's familiar with the
I
argument.
believe
Your Honor,
we want to hear your argument, not the co-agent's argument.
Your Honor, it was completely foreseeable. The Antarctic environment is highly specialized. The food chain is very simplistic. The animals, or the marine life, is of such a high degree of specialization that any injection of a hazardous waste, it is clearly foreseeable, would destroy marine life in the area and potentially upset the balance of the entire ecosystem, especially since it would be hazardous for 10
Well,
days.
if we assume that's true, Leonia was there as well. You had the last clear chance to prevent the harm and yet took no action. Why aren't you equally responsible?
Your Honor, Leonia's status on board the Ariana, the Vulpinian ship, was as an observer. The express terms of the treaty state that Vulpinia shall grant Leonia the right to have observers on board and to monitor. That is a very passive role.
Ms. Creighton, you can't have it both ways. You argue for an expansive interpretation in terms of the obligations and duties to which we should hold Vulpinia, and yet you ask us to make the most narrow and strict interpretations as to obligations that Leonia might have. Doesn't Leonia actually stand in a position where, as signatory to a wide range of treaties concerned with the environment, it has the highest obligation to take action whenever possible to protect harm, to prevent harm?
Your Honor, under the plain language of this treaty, they were there as an observer, and the subsequent practice after this treaty was signed demonstrates that this was not a joint undertaking, nor was Leonia there in an advisory capacity. After this was signed, Dr. Detritus was the one who was supposed to prepare for this. There is no indication in the compromise that at any time after that signature that Vulpinia sought Leonia's advice. And in fact, there is no indication that they relied on Leonia in their decision to discharge the waste. The Vulpinian team of technicians, which did not include Dr. Detritus because he was not on board the Ariana, went and called their government and informed them of the situation that existed. And the government told the team of technicians to go with the experts. They did not say, see what Leonia says. There is no indication that any consent was clearly established on Leonia's part. Leonia
But
did
you
not...
may have a positive duty. You rely on the Antarctic Treaty, you rely on customary international law. Perhaps above and beyond this exchange of notes, you have a positive duty to take affirmative steps to prevent this kind of discharge, if there's that obligation that you rely upon.
Your Honor, Vulpinia did not rely. There is no indication that Vulpinia relied on Leonia in any manner in carrying out this obligation.
We're not arguing that they rely, I'm not suggesting that they may have relied on it, but you may have had an affirmative duty to take action to prevent or to somehow discourage this kind of action until appropriate examination were taken. And failure to do that may give rise to certain responsibility on your part.
No, Your Honor, because under this treaty, we were there as observers. And
But
so
you were not there only under this treaty. You were there under the, you claim, I hear, the Antarctic Treaty, which relegated to you and the consultative parties extraordinary rights and duties with respect to Antarctica. I assume that carries forward when a state is about to discharge some hazardous substance into the very fragile, as you say, Antarctic environment.
Your Honor, under the Antarctic Treaty, Article 10, it says that states, when they act to pursue a violator, must act according to the principles of the United Nations Charter. Now, we had no rights there granted under that treaty to interfere, nor were we there in any advisory capacity. Thus, there is no consent. And in addition to violating the terms of the notes that were exchanged, Vulpinia has violated customary international law under the 1982 United Nations Convention on the Law of the Sea. Article 192 of the United Nations Convention on the Law of the Sea specifically obligates states to protect and preserve the marine environment. Article 194 obligates them to prevent, reduce, and control any form of marine pollution. And paragraph 5 of Article 194 specifically obligates states that in those measures they must seek to protect fragile ecosystems and preserve the habitats of unique forms of marine life.
But which way does that cut? Leonia has ratified the treaty. As I understand it, Vulpinia has not yet.
No, Your
Isn't the
Honor.
higher obligation once again Leonia's?
No, Your Honor. Leonia has signed the 1982 United Nations Convention on the Law of the Sea, as has Vulpinia. However, the obligations to protect and preserve the marine environment are codifications of prior existing customary international law. Principle 21, Articles 192 and Article 194, according to Jan Schneider and Alan Broyle, who are international publicists, have stated that that is a codification of Principle 21 of the 1972 Stockholm Declaration, that which says...
Is that a customary law or is it a treaty law, the Stockholm Declaration of 1972?
Your Honor, the Stockholm Declaration set out guidelines that were hoped that states would aspire to. However, Alexander Kiss, who is a French publicist, has stated that it is customary international law, and Professor Sohn would agree that it is customary international law. He has written that Principle 21, which obligates states whenever they have activities under their control which cause harm to areas outside their national jurisdiction, that they are responsible. And Professor Sohn has written that areas outside their national control specifically apply to the high seas and to Antarctica. Those provisions have been violated.
Well, you say violated. What was the duty? Is the duty a strict one? They have, was the respondent obliged not to discharge any waste into the Antarctic environment whatsoever?
Your Honor, if Vulpinia had not created the circumstances by which they felt they had to discharge this waste, it would be a different matter. But Dr. Detritus, who was acting as an agent of the state, did not adequately prepare for this retrieval effort. He was not even there. Dr. Detritus, the leading expert, was not consulted when this decision was made to discharge this waste.
Do we have in the evidence, in the record, evidence that the steps taken were unreasonable?
Your Honor, they were unreasonable because the compromise states that all the technicians knew was that after 10 days, the purity and salinity of the water would be restored. However, there were 10 days in which that waste would remain extremely hazardous to unique forms of marine life, to a highly specialized, unique environment that they had.
Yes, but there is dumping, there has been actions in Antarctica that have been deleterious to the environment. The states parties to the Antarctic Treaty have disposed of materials that have done damage. I would assume the state practice suggests that, to a certain extent, some discharge, some dumping, some activities that are damaging to the Antarctic environment are consistent with customary international law and the Antarctic Treaty. So perhaps this is within that, at least within that range of authority. States are right, part of states.
No, Your Honor, because this particular waste has been put in the annex of the 1972 London Dumping Convention and in the annex of the Basel Convention. May I continue, Your Honor?
Yes. Yeah, you continue.
As a type of waste that cannot be discharged. And that is precisely why the disposal of this particular form of waste was such egregious conduct in this situation.
But even that limit on discharge allows for emergency exceptions, does it not?
Yes, Your Honor. Under Article 5 in the 1972 London Dumping Convention, which Vulpinia has not yet taken any action on, there is a provision whereby when there is a threat to human life, dumping is allowed. However, that provision in paragraph 1 explicitly contemplates that no other action, that there is no alternative to that discharge. There was an alternative here. They could have left and come back with a better way to remove that waste, or they could have sought to have other drums brought into the area, but they did not. Thank you.
Thank you very much.
Thank you.
The court will now hear the co-agent. You have the floor.
May it please the court. My name is Michael Sharp, and as my co-agent indicated, I will be outlining exactly why this court should find that Vulpinia must be held liable for its actions during the Stella Maris incident and the appropriate remedies which are necessary to fulfill Vulpinia's liability-based obligations. In doing so, I will show the court three things. First, why Leonia has been both directly and morally injured by Vulpinia's acts. Second, why Vulpinia must be held strictly liable for its actions during the Stella Maris incident and for the extermination of the Antarctic starfish colony. And finally, the exact remedies which are appropriate in this case. As Ms. Creighton so ably outlined, Vulpinia is responsible to Leonia for a breach of right under international law. The relevant
You said
issue...
you were authorized by the, Leonia was authorized to act on behalf of the parties to the Treaty of Antarctica, was it?
Yes, Your Honor.
Yeah, what was the type of authorization you received?
Your Honor, that was an implicit authorization.
Well, what is implicit?
Implicit in
legal
that-
terms? Explain to the court, because the court is not aware what the word implicit means.
Following the incident, the consultative parties met and issued a communique stating that they themselves were not taking action, but were leaving it to the parties involved to take corrective measures. And Leonia, as one of the consultative parties, and as the immediate party to the February 2nd, 1988 exchange of notes, has standing to come before this court and claim, with this claim against Vulpinia. And the implicit authorization is based on that communique from the consultative parties, Your Honor. The relevant issue before the court at this point, though, is not whether Vulpinia is responsible. At this point, Vulpinia's responsibility is at least an underlying assumption. The relevant issue is the extent of injury which has been caused by Vulpinia's breach. Before addressing the most obvious injury, namely the regrettable loss of the Antarctic starfish colony, it is crucial that this court recognizes that Leonia has been both directly and morally injured by Vulpinia's acts. Leonia has first been injured by Vulpinia's breach of the February 2nd, 1988 exchange of notes. It is a recognized principle in international law that when a state breaches a bilateral treaty or obligation, that the non-breaching state has been injured. This principle has been recognized by the Permanent Court of International Justice, by this court, and by the most highly respected publicists. And as a permanent court held in the Chorzów factory case, when there is a breach of a bilateral treaty or obligation, adequate reparation is the indispensable complement to that breach.
When you say there has been a breach, you mean that they did not create the status quo ante?
Correct,
Is that
Your Honor.
correct? Well, was it conceivable that they could ever have recreated the status quo ante under that treaty? I mean, removal of the drums themselves, assuming they were totally sealed and never breached, there would be some change in the Antarctic situation as a result of the activity there and the drums having been placed there. So it's not absolute, is it? It's relative.
Well, Your Honor, it is absolute in that had they taken these drums away, all 100 drums without any discharge of waste, there would have been no effect on the Antarctic environment aside from any minimal effect from the discharge from the ships or the pollution caused by the ships.
Oh, so a minimal discharge would have been tolerable within the scope of the treaty agreement?
No, Your Honor. The minimal discharge would have been that which is understandable based on the engine from a ship, not discharging 5 drums of hazardous and corrosive waste into the Antarctic waters, resulting in the complete extermination of a species of marine life.
But that would have, it depends on the facts. If it was inevitable that in removing these drums there would have been some collateral damage, and this was that, and in fact based on what the parties appear to have known at the time of the discharge, they thought that it was a temporary damage that would not create long-lasting injury, that might well be within the idea of status quo ante.
If, Your Honor, the case was simply that there would have been some collateral damage. However, Vulpinia did absolutely nothing to determine the extent of the damage. For 11 months, they relied on Dr. Detritus, the so-called expert who placed these 100 drums of waste in the Antarctic environment, mainly because he had been shut out by other countries who were no longer willing to accept this hazardous waste. And upon seeing a newspaper article that there was unclaimed territory in the world, Dr. Detritus decided that this would be a good place to experiment with hazardous,
But
corrosive...
that's not really relevant, is it? You're not claiming any kind of damages based on the initial positioning of the drums.
No, Your Honor. However,
Your claim is based solely on the note.
Yes, Your Honor. But pursuant to that note, Vulpinia assumed the responsibility to remove these 100 drums of waste. And in so doing, they used the help of Dr. Detritus, the very person who put the drums up there.
But your counsel here argues that he was a well-known expert.
He was a well-known expert, Your Honor, in hazardous waste. He was not, however, a well-known expert in the Antarctic environment.
Well, the only apparent expert in the starfish environment was someone who was a national of your own nation.
Correct, Your Honor.
Why didn't you make certain that he was involved in this in any way when you initially went forward to execute the notes in the first instance?
Your Honor, this was not a joint enterprise between Vulpinia and Leonia. From the outset, Vulpinia assumed full responsibility for the removal of the 100 drums of waste. And if there was any responsibility to contact biologists or other Antarctic experts, that responsibility was Vulpinia's responsibility. And by not doing so, they showed bad faith and negligence in so performing their duties under the February 2nd exchange of notes, which is why, as my co-agent indicated, Vulpinia is responsible for a breach of right under the exchange of notes, even under the good faith or due diligence standard before the court. But should the court...
On what do you base your argument of bad faith? Perhaps if the removal has been ultra-virus.
Your Honor, the bad faith comes in the fact that Vulpinia did nothing aside from relying on Dr. Detritus. And Dr. Detritus' acts, once he was acting as agent for Vulpinia, his acts are imputable to the state of Vulpinia. And Dr. Detritus took no other measures with him or any alternative measures, that is, to remove the waste from the Antarctic region, nor did he take the appropriate measures to determine the exact extent of damages which might be caused. The compromise only states that Dr. Detritus' experiment showed that the seawater would return to its original salinity.
Well, he was in fact correct, was he not?
He was correct that the seawater would return to its original salinity, Your Honor. However, there is nothing in the compromise indicating that Dr. Detritus had any idea the effect that this hazardous waste would have on the marine life in the area.
Well, no one had any idea at the time the drums were removed, did they?
Your Honor, it is foreseeable that when you discharge hazardous, corrosive, and explosive waste into the Antarctic waters, that there will be some form of damage to the sea life. This is the least polluted area in the world, and seas which are the most abundant in marine life, and clearly discharging 5 drums of hazardous waste will cause some damage. But even if the court were to find that Vulpinia had acted in all good faith and reasonably, Vulpinia must still be held strictly liable for the extermination of the Antarctic starfish colony.
Would you be here if the damage to the starfish colony was determined only, say, 10, 15 years after the dumping of the barrels?
Your Honor...
How long does this duty or after determined effects damage go?
Your Honor, if this were 10 or 15 years later, there might be some question as to, first of all, whether there would be clear and convincing evidence that the acts of Vulpinia had caused the extermination of the Antarctic starfish colony. However, based on the standard of clear and convincing evidence, it is unquestionable, both by the facts and according to the stipulated facts in the compromise, that the discharge of the waste by Vulpinia caused the extermination of the Antarctic starfish colony. And as such, Vulpinia must be held strictly liable for that damage. The strict liability regime has a broad and ever-increasing acceptance in the field of international law, especially in regards to environmental harm arising out of hazardous activities. Perhaps the earliest and certainly one of the most quoted cases of strict liability comes from the 1935 trail smelter arbitration between the United States and Canada, a case in which the arbitral tribunal held that Canada must compensate the United States regardless of fault for environmental harm to the U.S. which originated in Canada.
Now, did the arbitral tribunal in the trail smelter case rely on international law only?
No, Your Honor, it relied also on the stipulations of the parties in the case.
Not only.
Well, as well as international
and American law.
And in the stipulation, Your Honor, Canada, in all good faith and as a responsible member of the community of states, accepted the responsibility for the trail smelter incident. Just as in this case, Vulpinia must accept the responsibility and the liability for the extermination of the starfish colony as a responsible member of the community of states.
We might agree that we'd like to have that happen, but certainly they didn't accept that responsibility when they signed the note on which your claim is based.
No, Your Honor, but they accepted the responsibility of removing 100 drums of hazardous waste from the Stella Maris region,
Well, they
and they
did that.
accepted... and the responsibility of restoring the area to its previously existing state. That cannot happen. There is an entire species of marine wildlife which no longer exists. And to this day, we still do not know the full extent of that damage. It could well be that these starfish played a crucial role in the Antarctic food chain, which is why Vulpinia must be held strictly liable and provide compensation to the entire community of states to determine exactly what role these starfish played. Without that knowledge, we will not ever know the full extent of damage until it comes up in perhaps a more egregious fashion.
Let me ask you, you argue for strict liability. What are the policy consequences of holding states strictly liable for damage to the environment?
The policy consequences, Your Honor, especially within the past 15 years, when the concept of a common heritage has come into the international law regimes, will be to protect those common heritages by forcing states to act with all proper due diligence in their activities within the common heritage. This
No, it isn't common heritage yet. We don't know what will happen.
Correct, Your Honor. The common heritage concept, though, has
Depends
been...
on the legislator whether they will adopt the system of common heritage.
Correct, Your Honor. However, as the court knows, the common heritage concept is accepted in international law, and pressure has been rapidly mounting to include Antarctica within the common heritage. And while this pressure has mainly come from the 100 or so non-aligned countries who are not yet parties to the Antarctic Treaty, even the consultative parties, which have historically been reluctant to include Antarctica within the common heritage, have stated in their most recent recommendations that the activities of the contracting and the consultative parties should in no way prejudice the interests of all mankind in Antarctica.
Yeah, that's true, but let's accept hypothetically the possibility of this becoming common heritage of mankind. Does that imply strict or absolute liability?
Your Honor, it would not necessarily imply that should the subsequent treaty or subsequent modification of law not state that there should be strict liability. However, based on the fact that the damages here are a form of environmental harm, the international law treaties and the international law regimes have recognized that when there is environmental harm arising out of hazardous activities, strict liability must be the norm. Whether it be injuries from airline...
What are the authorities you rely on?
Your Honor, the first authority are the outstanding treaties, whereby whether it includes injuries from airline accidents, injuries from space exploration, injuries from...
Well, space exploration, is it a general rule or is it a special treaty providing for strict liability?
That particular case, Your Honor, given the prohibitive expenses of using the space, would be a specific rule.
Well, it's a special treaty.
However, in the International Convention for Civil Liability for Oil Pollution Damages, there is a more general rule which imposes strict liability for oil-related activities. And in the 1980...
Then you have the authorities rely on specific treaties, not on general international law.
In this case, it would be a specific treaty.
Yeah,
However, the fact, Your Honor, is that even in this treaty, where there has been, up until 1984, strict liability only for oil pollution, following 1984, there was an amendment to the treaty which included the addition of 45 substances, and among these substances are hazardous substances which are much less dangerous than the corrosive and explosive waste discharged into the Antarctic region. And furthermore, even publicists, respected publicists, who would not be general advocates of strict liability on a broad basis, have held that when there is environmental harm from hazardous activity, there must be strict liability. In fact, Professor Handel, himself not a broad advocate of strict liability, has stated that when there is environmental harm from hazardous activities, the state which engages in a significant risk of transboundary harm must be held strictly liable for that harm.
Did that happen in Chernobyl?
Your Honor, the activities in Chernobyl were within the boundaries of Russia and caused by Russia. As such, it was not within the common heritage of mankind. And clearly the fallout over the northern European countries, it would be a question, and unfortunately that question did not come before this court. And the case before the court today is one of first impression.
Yeah, but the practice that resulted from that and other major cases of environmental injury haven't seen a strict, unlimited liability on the part of the polluter.
Your Honor, we are not asking for an unlimited liability. We would ask that this court would put a cap on any damages today, so that should there even be additional damages based on the starfish's role in the Antarctic food chain, that Vulpinia will not be left open to further damages. We are not here to punish Vulpinia. We are here because there has been damage to the world community, and Vulpinia must be held responsible and liable for those damages. But your concern, Your Honor, if I understand your question, is that there are cases, Chernobyl for instance, where there has been international damage without the strict imposition of liability. An analogous case would be the situation between the United States and Japan, where Japan was complaining of the nuclear fallout from the nuclear test done by the states. And in that case, America, as a responsible member of the world community, paid millions of dollars ex gratia. Yes, Your Honor.
Ex gratia.
As a responsible member.
Yeah, but not as an obligation, but ex gratia payment.
Correct, Your Honor.
Yes, sir.
However, the
And it was many years ago. Law has developed since.
which, based on inflation, Your Honor, would mean that the damages before this court today should be even higher.
How are, assuming you're right, that the damages are appropriate, how are we to calculate what the amount of those damages will be when, as far as we can tell, Leonia has suffered no damage that's different from any other state, and when such action as can be taken has already been done?
Your Honor, first of all, Leonia does not come before this court solely for damages on its own behalf. Leonia comes for damages on behalf of the entire community of states. The compensation must take the form of a fund which, under the administration of Leonia, will be used for the research to determine exactly what role these starfish played and to take any preventive measures to support the existing wildlife.
Can it be that Vulpinia really thought this was what it was getting into when it signed this note?
Your Honor, it may not be that that's what they thought they were getting into, but they did know they were getting into the removal of hazardous and corrosive waste from the most pristine environment in the world.
Does the note speak at all to what kind of damages either party may be subjecting itself to if it takes action in violation of its obligations under the note?
No, Your Honor, it did not. However, in expressing your concern about what damages the court should determine, this court should rely on statute, Article 50 of the court statute, as well as the court's earlier holdings in cases such as the Corfu Channel case, where the court went to outside experts to determine exactly what the proper remedies would be. And in this case, outside experts could clearly determine the cost of research and the cost of preventative action to support the Antarctic wildlife. The only impediment to imposing liability in this case is that allegedly no one state has been injured. The better view, in fact the correct view, is that the entire community of states have been injured, and that Leonia, as the immediate party to the dispute, should be awarded damages on behalf of those states, which will be used solely for the benefit, protection, and future enhancement of the Antarctic environment.
What legal authorities do you have to support the idea of that kind of remedy?
Of the fund, Your Honor?
Yes.
Funds of that sort already exist in international law. In fact, as early...
Judicially established.
Judicially established, there are none as yet, Your Honor. This is a case of first impression before the court. However, this court can rely on state practice as well as international law. And in the trail smelter arbitration, may I finish? In the trail smelter arbitration, the money which was paid to the United States was paid in the form of a fund to compensate the victims of that environmental harm. And in the International Convention on Civil Liability for Oil Pollution, the strict liability in that case takes a form of a fund which is used to compensate states which are damaged.
And that's a special treaty.
Yes, Your Honor.
Yeah. Well, anyhow, you want this court to give a judgment, a presidential judgment on the subject.
Yes, Your Honor.
All right.
Thank you.
Mr. President, Your Excellencies, my name is Darrell Cruz, and I am first counsel for the respondent, the state of Vulpinia. I will be addressing whether Vulpinia has breached any rules of customary or conventional international law in this case. My co-agent is Melanie Aiken, and she will be addressing issues concerning reparations or remedial measures. I would like to state at the outset that the loss of the starfish in this case is a tragedy. In some sense, whenever a species disappears, man has suffered a loss as well. But while this is a loss that must not be trivialized, the disappearance of the species is not in itself reason for this court to find in favor of the applicant. In particular, this case is about international law. Indeed, it is the duty of this court, under Article 38 of its statute, to decide this case in accordance with international law. My friends for Leonia are claiming that Vulpinia has breached international law in two respects. First, that it has breached customary norms of environmental protection arising out of customary international law, and second, that it has breached bilateral treaty obligations contained in the exchange of notes. I propose to deal with each of these submissions, and in particular, I have three principal submissions. First, that Vulpinia has not breached any binding bilateral or multilateral treaty obligations pertaining to Leonia. Second, that to the extent that Leonia's claim is based upon customary international law, it does not have standing to pursue that claim. And thirdly, that in any event, Vulpinia has acted with reasonable care in response to the events at Stella Maris, and as such has not breached any rules of customary international law. I would like to turn first to the question of customary law and the important question of standing, which has been raised already in this court today. Mr. President, Your Excellencies, to the extent that Leonia's claim is based upon customary international law, it does not have standing to pursue that claim. There has been no damage to any Leonian interests recognized by law. Leonia has not suffered any damage to its territory, to its nationals, to its ships, or its exclusive economic zone. What Leonia's claim amounts to is a claim on behalf of all nations for damage to the common environment. And this court, in the Southwest Africa case, explicitly recognized that such an actio popularis is inappropriate at international law.
But that isn't an actio popularis, is it?
Mr. President?
It's, Leonia is acting on behalf of a number of states, not the international community. In fact, 32 states, as you will remember, because 32 states are involved in the Antarctic Treaty. So it isn't an actio popularis. These states may have authorized Leonia to act on their behalf. They didn't appear before the court, as I mentioned at the beginning, but Leonia may act on their behalf. So it's not actio popularis.
Yes, Mr. President. However, my friends in argument today have submitted that Leonia is claiming damages on behalf of the community of nations.
Well, the court hasn't yet recognized this claim. The court wants to listen to your view.
With respect to their claim on behalf of the consultative parties to the Antarctic Treaty, it is Vulpinia's submission that Leonia is not here today on behalf of those parties. As my friends have indicated, subsequent to this incident, there was a meeting of those consultative parties, and a joint statement was issued by the chair of that meeting. There was an expression of regret for the loss of this species, but no authorization for Leonia to pursue this claim before this court today. My friends have relied on Article 10 of the Antarctic Treaty, which indicates that all treaty nations have an obligation to ensure that the objectives of the treaty regime are pursued. Article 10 only creates obligations inter se between the parties to that treaty. It does not give Leonia standing before this court. And similarly, the other nations of the Mr. President?
No, it's not correct. You quote Article 10, which says that each of the contracting parties undertakes to accept appropriate efforts consistent with the Charter of the United Nations to the end that no one engages in any activity in the Antarctic,
Yes, Mr.
contrary
President.
to the principles and purposes of that treaty.
Yes, Mr. President. It is Vulpinia's submission that that provision creates obligations between the parties, such that if one party observes another state that it feels that that state is breaching international law relating to the Antarctic, it has an obligation to follow the treaty regime and pursue that other state. But it does not give standing before this court. It merely creates obligations between the parties to the Antarctic Treaty and no more.
Well, this obligation may have become customary law.
That is correct. And to the extent that my friends are suggesting that the Antarctic Treaty has become customary international law in the sense that it has become an objective regime, it is Vulpinia's submission that there is no objective regime in place in this case. In particular, an objective regime is contrary to the consensual nature of international law.
Before you go deeper into that, if we accept your arguments on this, then we have a tragic injury to the Antarctic and global environment, and no state can remedy it. Is that the situation under international law?
Your Excellency, it may very well be the unfortunate situation that no state can bring a claim before this court to seek redress. Indeed, this court in the Southwest Africa case said that in the international field, the existence of obligations that cannot in the last be enforced by any legal process has always been the rule rather than the exception. However,
But are there not legal duties applicable to your state with regard to discharges in Antarctica? Are you unregulated by international law?
it may be, Your Excellency, that we are not unregulated if there is a hard customary obligation. It is simply that if these obligations exist, there must be damage to a particular state's legal interests before they can bring a claim before this court. Given the decision of this court, however...
But you relied on the Southwest Africa case of 1966.
Yes,
The court needn't necessarily rely on it. It may rely on some dissenting opinions. The stare decisis rule doesn't apply to this court.
that is correct, Mr. President. This court statute
That's right.
indicates that
And
such a...
further, the question is the definition of what injury is and what legal injuries are. And there may be legal injuries having been suffered by the applicant, which would give them standing.
There is dicta in international law, Your Excellency, that simply breach of an obligation is enough to trigger responsibility. However, it is submitted that in this environmental field, where we're talking about the common environment, there must be some damage before a particular state can bring the action. This court's decision in the reparations case regarding injuries suffered in service of the United Nations recognized that the United Nations has international legal personality. And to the extent that this court is concerned that no one will be able to pursue a case for damage to the common environment, it may be that the United Nations has...
Well, what is common environment? We speak of the Antarctica, and that is an ancient regime, isn't it?
The common environment in this case, Mr. President, is the high seas, in that the disposal of these wastes occurred in the waters off the Antarctic regime.
You don't recognize the regime of the Antarctica?
We recognize that there is a regime existing between the parties to the Antarctic Treaty. However, that party is not binding upon third states, and such a conclusion would be inconsistent with the wording of the Vienna Convention on the Law.
Not binding on third states. So why do the third states now try to change that regime? If they consider that it's non-existent, there is nothing to change. But they're still trying to change it in the United Nations. In
Well,
fact, they recognize it.
Yes, Mr. President.
It's not null and void. It may be voidable, but it's not null and void.
Yes, Mr. President. And to the extent that the other nations of the world object to the existence of an Antarctic regime, it is Vulpinia's position that such objections must go to all provisions of the regime, not merely the environmental ones, but
But
the
they
entire
haven't
structure.
altered it yet.
But in any event, what you're claiming is at issue here is the high seas, not the Antarctic environment.
That is correct, Your Excellency.
Well, then what do you do with your opponent's argument that the wastes that are involved here were covered both under the Basel Convention and the Law of the Sea Treaty?
With respect to the Basel Convention, Your Excellency, the Basel Convention was first signed on March 22nd, 1989. The events in this case occurred in January 1989. In accordance with Article 28 of the Vienna Convention on the Law of Treaties, treaties are not retroactive. In any event, the Basel Convention is not yet in force, and any obligations under that treaty would merely be to conform to the object and spirit of that treaty. With respect to the dumping...
Well, did you in fact believe that you were conforming to the spirit of the treaty when you discharged this waste into the...
The treaty had not yet been prepared for final signature, and so there is no question as to whether Vulpinia conformed to the object and spirit.
Well, I'm
in a
asking the
technical
question,
sense.
though, here this morning.
Well, the Basel Convention regulates the transboundary movement of hazardous wastes, and its main thrust is to allow states which do not want hazardous waste exported to their country to object to that, and at international law, the international law would recognize such objection as valid. In this case, considering that we have no other state who has objected, the basic thrust of the Basel Convention has been conformed to.
So then does that mean that if this were to happen tomorrow, you'd be free to act exactly with respect to the drums as you did in 1989?
Madam President, there is in the Basel Convention, Article 4.6, which indicates that no states shall deposit wastes in the Antarctica. My friends have argued in the memorial that this is a codification of customary international law. It's Vulpinia's position on that point that it is not such a codification insofar as the Basel Convention purports to absolutely prohibit the deposit of the transportation of hazardous waste to the Antarctica. With respect to future obligations, it will be Vulpinia's submission that the essence of the Basel Convention is a state turning its mind to the consequences of hazardous wastes and acting reasonably in that regard. So until the Basel Convention actually comes into force, it will be Vulpinia's submission that the reasonable character of Vulpinia's actions in this case would not violate the object and spirit of the Basel Convention.
But let's assume that the convention is in force.
Yes, Your Excellency.
What's your answer to the question?
If the convention is in force, then Section 4, Article 4.6 clearly would restrict Vulpinia's ability to transport waste to the Antarctic.
And so had the convention been in force when these acts occurred, you would be in violation of it? Is that your position?
That is correct. And indeed, Vulpinia has signed the Basel Convention subsequent to these incidents in order to show that we are cooperative and that we do have a commitment to the environment. And we have stated that from the outset.
So then the only thing that prevents us from finding liability here is the fact that this convention was not in force.
The only thing that prevents this court from finding liability is the state of international law at the time these events took place. And this court has to decide in accordance with international law at that time. And at that time, there was no international law prohibiting absolutely the transport or disposal of waste in the Antarctic.
And I take it you would also ask us to conclude that notwithstanding that the convention was not in force, but that you were in a position where you were about to sign it and ratify it, that your conduct was nonetheless consistent with the spirit, the obligations of the convention, which is now about to become binding upon your state.
Yes, Your Excellency. The question for the court, the most important question for the court today, is what sort of obligation exists, assuming that there is a customary obligation of international law. My friends in their memorial have referred to the Stockholm Declaration, and Vulpinia, in its memorial and here today, accepts the tenor of the Stockholm Declaration and accepts that there is a general obligation to protect the marine environment. It is important for this court, however, to consider what it means to say that there is a general obligation. This obligation is founded upon the Stockholm Declaration and the World Charter for Nature and similar instruments, which indicate the international community's moral and political intent. These documents do not create binding legal obligations in the same sense as a multilateral treaty would.
But there were developments. There have been development after the Stockholm Declaration, and the authority of Professor Sohn was invoked in this respect. What are your views on Professor Sohn's conclusions?
Professor Sohn's views and subsequent developments, including the passage of various conventions, including the Antarctic Conventions on Minerals Activity, which has not yet entered into force, and the Marine Living Resources Convention, indicate that states do have concern about the environment. However, it is of the utmost importance for this court to recognize that customary international law does not adequately deal with pollution in these circumstances, in that when one looks at the London Dumping Convention, the Basel Convention, and similar multilateral conventions, the provisions are very specific. They have lists of annexes which deal with particular substances. They have very technical provisions which customary international law, in its character as a slow-moving instrument of law, a slowly changing instrument of law, cannot deal with these important issues. And it is the multilateral convention that best deals with this sort of problem.
But we're not talking about a detail. We're talking about the elimination of a species by disposal of clearly identified hazardous waste. And you're telling us today that customary international law frees states to do that? There is no limit to what states may do with respect to that?
Your Excellency, there is a general obligation to protect the marine environment on a moral and political level. And insofar as states are willing to impose political sanctions on other states for conduct which may violate this general obligation, such acts would not go unredressed.
There's no even due diligence standard applicable to all activities that might affect the world environment?
There may be a due diligence standard. There may be an obligation to prevent harm to the environment that is willful and which indicates clear negligence. In these cases, however, the idea is what obligation exists. Is this an absolute prohibition against the transportation and disposal of wastes in the Antarctica? And when one looks at the
Well, you spoke of political sanctions, but we're dealing with the legal issues.
That is correct.
So in replying to my brother's questions, you should deal with legal aspects.
It would be Vulpinia's position that there is no legal obligation which prohibits the transport or disposal of hazardous wastes to the Antarctic. With respect to the London Dumping...
Notwithstanding the Antarctic Treaty and the recommendations that have come out of that?
Yeah.
The Antarctic Treaty, as I've indicated, does not create an objective regime binding upon third
Now,
states.
what's your authority for stating this? I tried to prove you that states have recognized this regime by trying to change it. Well, is that not an act of recognition?
My submission, Mr. President, would be that in Article 35 of the Vienna Convention on the Law of Treaties,
Yeah.
in order to have third states bound to treaty obligations, they must consent to those obligations in writing. Similarly, the consensual nature of international law recognizes that legal obligations cannot be placed upon on an obliger state without its consent.
Well, we may not only have a third-party right or duty, we may have customary international law. If you look at the records of the debates on Antarctica in the General Assembly, there seemed to be widespread consensus that rules regarding the Antarctic environment are accepted worldwide. There's no dissent.
Your Excellency, the Antarctic regime is not a fixed regime. It is up for review in 1991, and...
Oh, we are in 1990, in the beginning of 1990.
Yes, Mr. President. However, the
Our
fact that...
judgment is to be operative as from today.
Yes, Mr. President.
That's right.
But the fact that this treaty is not a fixed, does not create a fixed regime militates against an argument that all of the provisions of that regime indicate that there is customary international law.
I'm talking about all provisions, I'm talking about environment, and I recognize that international law changes in all respects over time, but today and at the time of this discharge, was it not clear that all nations accepted a special duty with respect to the Antarctic environment, which your state may have violated?
As Your Excellency indicated in questioning my friends, there is disrespect shown by Antarctic consultative parties to the Antarctic environment currently. Indeed, Professor Auburn, in his work Antarctic Law and Politics, has recognized that there is damage to the environment occurring regularly, and states, including consultative parties, have been delinquent in this regard. And to suggest that there would be a customary obligation arising out of the Antarctic Treaty would be inconsistent with the actual state practice in the region.
Well, the state practice with respect to some activities may not apply to other activities. We're talking about the discharge of highly toxic waste that has eliminated a specific species. We're not talking about normal dumps that were used for living on Antarctica or other activities that aren't nearly as hazardous as the activity that you're talking about. Perhaps some of those might fall within this particularly dangerous type of behavior that your country is accused of engaging.
Yes, Your Excellency. Indeed, my friends, in referring to the London Dumping Convention, have indicated that there appears at first glance to be an absolute prohibition on the disposal of hazardous wastes listed in Annex 1 at sea. It would be Vulpinia's submission that when one reads paragraph 8 of Annex 1 of the London Dumping Convention, it is clear that that convention does not prescribe the disposal of wastes which are rapidly rendered harmless by processes in the sea and which do not harm humans or human food sources. So even under the major multilateral convention on the disposal of wastes, if it were to apply directly, which it does not in this case, such activity would not be prescribed. I see that my time is running short. If I might briefly address the question of the bilateral treaty obligations in this case arising out of the exchange of notes. Mr. President, Your Excellencies, in this case, the most important thing to consider about the exchange of notes is that they were entered into without any prejudice to the legal positions of the parties. Indeed, it is important, in this case, Vulpinia submits that the effect of the words "without any prejudice" is that first, it indicates an unwillingness to consent to be bound by treaty obligations, and secondly, that in any event, if this does constitute a binding agreement between the parties, that the words "without any prejudice" must be interpreted as part of that agreement, and as such, do not impose a mandatory requirement that Vulpinia removes 100 drums from the Antarctic Treaty. Our third position on the exchange of notes is that Leonia, by its conduct in this case, and its failure to object to the disposal of these wastes, has acquiesced in the disposal of the wastes, and as such, is stopped from relying on the exchange of notes. With respect, Mr. President?
Yeah, you go on.
With respect to the words "without any prejudice," Article 13 of the Vienna Convention on the Law of Treaties indicates that consent to be bound is required for treaty obligations to arise. In Article 32, it is indicated that the travaux préparatoires are to be considered in interpreting whether such obligations have arisen and interpreting the meaning of treaty. In this case, where Vulpinia has denied from the outset that it had any legal obligations pertaining to Leonia, to interpret this agreement as binding would have a chilling effect on diplomatic practice. The registration...
But the text of the agreement speaks for itself, doesn't it? You undertook an obligation to remove the 100 drums, didn't you?
If one ignores the phrase "without any prejudice," that might be the case. It is Vulpinia's submission that those words...
Well, without prejudice concerns a different thing, but the obligation was to remove the 100 drums.
On its face, yes, Mr. President.
That's nothing to do without prejudice.
That is the initial premise,
Well,
Mr. President.
well,
Yes.
that is an obligation. Have you performed that obligation?
In this case, Vulpinia would accept that it has not performed the obligation
Yeah,
to remove
all right.
100 drums.
So you failed to carry out the agreement, didn't you?
No, Mr. President, because of the effect of the words "without any prejudice." And Vulpinia would submit that in interpreting this agreement, the words "without any prejudice" have the effect of indicating that Vulpinia's...
Now, we leave the word "without prejudice" as part. We speak of the obligation. You have a specific obligation.
Yes, Mr. President.
And without prejudice concerns your legal views on the subject, and not of the obligation,
Without prejudice,
because the obligation is strictly defined.
Mr. President, it is Vulpinia's position that "without prejudice" refers to the entire legal positions, including the nature of the
Well, it
obligation.
doesn't condition the obligation. It conditions something else. It doesn't condition the obligation as such.
In any event, Mr. President, as I previously indicated, Vulpinia's position is also that Leonia's conduct in this case allows it to be stopped in accordance with the decision of this court in the Temple of Pravir case from relying on this exchange of notes.
But you've admitted, I gather, that you didn't satisfy the obligation under the bilateral treaty. You didn't remove the drums. So
If the
doesn't
words
that-
"without prejudice" do not have any effect, that would be the case.
Well, I think that the President's questioning is persuasive here. You're in a situation where you violated your obligation. Doesn't it follow that we must now address the question of liability and damages?
Your Excellency, this court has recognized that where a legal right exists and a state does not insist on the performance of that legal right, then it cannot subsequently claim that its rights have been violated. That is the principle of estoppel as enunciated and indicated in the Temple of Pravir case. In this case, Leonia has said that they have acted only as observers on board the Ariana in this incident. In my submission, however, Leonia's government officials on board the ship contacted the Leonian government itself, and the Leonian government, knowing the circumstances, failed to object, and as such
To
is
what?
stopped.
Failed to object to what?
To the disposal of the waste, Mr. President.
Well, because you had to dispose of the waste. That was the waste, because that was your obligation, wasn't it?
If
They were
Leonia,
observers only.
You're saying that they essentially, in that phone conversation, amended the note.
no, Your Excellency, what I'm saying is that Leonia contacted, the Leonian observers contacted its government, and its government made a decision not to intervene. When they claim that a customary rule of international law has been breached,
But I'm talking about the breach of an obligation in the note.
yes, Your Excellency, but they're also claiming that a customary rule has been breached, and it would be Vulpinia's submission that in such
But
circumstances...
that's not the question I asked you. I'm concerned about the fact that you've admitted that there's a breach of your obligation in the note, and my question is, doesn't that put us in a position where we now have to consider what kind of damages, what kind of liability you have for that breach?
I see that my time is up, Your Excellency, if I might briefly answer your question.
Yeah, we don't depress you. We only want you to help us to reach a just decision.
Yes, Mr.
That's the objective of the enterprise.
Yes, Mr. President. It is simply Vulpinia's submission that in these circumstances, if Leonia seriously believed that there was a breach of customary international law, and if it believed on the face of the agreement that there was going to be a breach of the exchange of notes, that these circumstances would be crying out for an objection, and Leonia failed to object in these circumstances. If I might briefly conclude, Mr. President.
Yeah, thank you very much. Yes, you have the floor.
Mr. President, Your
Are all
Excellencies.
ears.
My name is Melanie Aiken, and I am second agent for the respondent, Vulpinia. I shall be addressing the second question submitted in the compromis, of equal importance to be considered by this court today, that of reparations. Should Vulpinia be found to have breached some right pertaining to Leonia, she is nonetheless under no obligation to provide remedial measures or reparations. I shall be making three principal arguments with respect to this submission. Firstly, the claim brought before this court by Leonia for damages is both inappropriate and unjustified. Such a claim urges this court to abandon long-established notions with respect to the awarding of damages and to potentially venture beyond its jurisdiction. Secondly, should this court indeed find damages appropriate, any such award should be denied, or at the very least, substantially reduced by a subsequent consideration of contributory fault. And thirdly, it is the respondent's submission that this court should find that full and due satisfaction have in fact been made to Leonia by virtue of the apologetic and cooperative course of conduct undertaken by Vulpinia throughout this incident. In the alternative, at the most that would be consonant with international principle and practice, a declaration of a limited effect might be appropriate. Proceeding now to the first of my submissions. The claim brought by Leonia for damages is inappropriate. There has been no damage in this case, which international law recognizes as being compensable. Firstly, as no actual damage, pecuniary or material, has been suffered by Leonia, she is precluded from bringing this claim.
Does damage have to be pecuniary or material under international law to justify a remedy?
It is submitted that the practice in the international sphere has restricted an award of damages to where a demonstration of damage, either pecuniary or material, has been so demonstrated.
What's the purpose of damages?
The purpose of damages is, if possible, to reestablish the status quo ante, to redress an injury sustained. And it is simply our submission that indeed no injury has been sustained by Leonia in this case.
But if the status quo ante cannot be reproduced, is there no remedy under international law?
It is our submission that there must be some injury proven to have been sustained by the community of nations or by Leonia to even consider a claim for damages.
Well, we've lost a species to mankind. Is that not sufficient?
It is my submission that it has not been demonstrated that in fact any loss has been sustained, which this court can so recognize. Any attempt by this court to quantify some future value the starfish might have had to the international community would necessarily engage your excellencies in a consideration of loss which is purely speculative in nature and as such has been clearly held in the international sphere to be uncompensable.
But if I understood the applicant's request, it is not to pay them money that they can spend on whatever they wish, but rather to create a situation that might, in a way, compensate for the loss to the Antarctic or world's environment, to set up a trust fund, to manage it in some way that's environmentally productive. And so we're not talking here, I gather, about actual payment of money that they can use for whatever purpose. And in that case, we are getting, the proposal is to approximate as much as possible the status quo ante.
It is simply my submission that as there has been no commercial value and interest demonstrated by Leonia, or indeed by any state, for we have no evidence before the court as a result of Leonia's failure to impart to all nations the existence of the starfish, there is nothing which can
Is
unfortunately
commercial
be
value the only test for damages?
It has been noted by Dr. Smith that with respect to marine resources,
By whom?
Dr. Smith,
I see.
that damages...
Smith?
Who is Smith?
Oh, these Smiths.
Smith, oh.
That's right. Oh, it's an authority. You quote as authority, do you?
Yes, I do, yeah.
All right.
As
The
he
court will
noted,
consider it.
as he noted, damages for loss of marine resources are very limited, and for damages which occur beyond the territory of a state, all that they can damage depends upon the historical exploitation of this resource. And indeed, it has not been demonstrated. And again, I reiterate, the reason we have no evidence before this court is that Leonia failed to impart to all states the knowledge of her national with respect to the awareness of this species.
Was it Leonia's duty?
It is our submission that it would be most consonant with Leonia's positive obligation under the Antarctic Treaty, as Your Excellency pointed out, and with its undertakings in various conventions, to have in fact objected, if they so found, the manner which Vulpinia proposed to deal with this waste, to make some objection, to register some reservation. Leonia, it is submitted, did not. And further,
But did
What of
Leonia
that,
have
I'm sorry?
knowledge of the existence of the species and
Yeah.
its risk to loss?
it is our submission that the very foundation of the claim brought before this court by Leonia, and indeed the reason we are here, rests upon an application of the principles of state attribution. And indeed, in our submission, if state attribution runs one way, it must, in all equity, run both.
Is a nation responsible for the knowledge of all its citizens?
It is submitted that, in this case, it is even more clear that Leonia should have known about her national. Leonia's zealous
Doesn't that
observation...
argument run against you because you should have known about the activities of your national and stopped this in the first instance?
It is my submission, and I approach on the basis that a breach has been found on Vulpinia, and it is simply my wish now to attribute the knowledge of Professor Handlin to the state of Leonia. For Leonia was zealously observing all activities in the Antarctic and had undoubtedly uncovered the presence of her national conducting experiments therein, and who, moreover, was not unlikely financed by her state.
Well, now let me make certain I understand this, and I was a little confused when I questioned your co-counsel. What you're saying is that we can assume a breach has occurred. There is a violation here that we're talking about, and now our question is whether, having established a breach of an obligation, whether from the bilateral treaty or from some other source of customary international law, damages ought to be awarded. Is that your position?
That is absolutely so, Your Excellency.
Well, now, if that's your position, a moment ago you commented that it was commercial value that should guide our determinations, but doesn't that put us in the anomalous situation that the only losses that we can compensate are those that are perhaps the most trivial? The greatest losses, those that cannot, at this point in time, be valued, are the ones precisely that we would like to address, and yet we're stopped from doing so under your approach.
I understand your difficulty with that point, and we do recognize the paradox therein. But what is peculiar about this case is not the loss of the species, for if we had 50% of them left, and you suggest we could then quantify, it would make no difference. It has been no more established that there has been a loss to the community of nations. What is peculiar about this case is we have no prior acquaintance with this species, and I will reiterate that it is Leonia's failure.
We ought to have a duty to exercise care, in the greatest duty, I should say, to exercise care, where we may be damaging something, the value of which we cannot now establish. I mean, you'd have us allow states to go forward, and as long as they are operating in areas where the scientific knowledge is not yet complete, do whatever they wish.
It is my submission that unfortunately that may be the case if the harm occurs in an area which is not the territory of any state, and in fact we have no evidence with respect to it, and there has been no historical exploitation of that resource.
It's no territory of any state. You argued in your memorial that it's terra nullius.
That is correct.
You maintain this view?
Yes, I do.
You do?
It is not in the territorial sovereignty of
terra
Leonia.
nullius. It may be occupied by anyone, is it?
It is simply that it is not under the control or the sovereignty of any state.
What about the provision of the Antarctic Treaty, which has frozen the claims of all those who made claims to the Antarctic?
I would simply have to rest on my co-agent's submissions with respect to the Antarctic obligations are not binding on third parties, and thus it remains to be terra nullius and not within the control.
You're going to deal with it, are you?
Pardon me?
You're going to deal with it?
The Antarctic regime, as my co-agent has established, is not binding upon
but
Vulpinia.
you link, your argument is connected with that claim,
Yes, it is.
which is not substantiated, because you have no basis for such claim to consider Antarctica as terra nullius.
It is simply our submission, and I would have to rest on it.
Yeah.
That is the way we should
All
treat
right.
that territory. My friends submit a request for damages in another capacity for a mere breach of sovereignty of the bilateral exchange of notes. They rely exclusively upon the I'm alone case for such a proposition. It is our submission that it stands for no such proposition. In that case, as was recognized by Mr. Charles Cheney Hyde, formerly Solicitor of the Department of State, the claim brought by Canada to the tribunal embraced a claim for legal costs and for repatriation of the crew, together amounting to almost $34,000. Thus, it is our submission that the award recommended by the tribunal of $25,000, specifying as it did not the heads to which these were to be applied, stands for no such proposition that damages can be awarded upon mere breach of sovereignty. For my friends to suggest that this case does so stand for such a proposition would run contrary to the pervasive attitude exhibited in the international sphere, and, insofar as my friend's claim relies exclusively upon this case, it is our submission that in international law, the I'm alone stands alone. With respect to my friend's request for a trust-type award, it is our submission that aside from very grave considerations of the absence of an enforcement mechanism, such a remedy runs contrary to the rationale of damages, the reestablishment of the status quo in ante. Such a remedy, seeking to fund aims exclusively in the future and for ends as yet undetermined, is, we submit, contrary to the idea of damages. Such a claim urges this court to legislate, to create obligations, and to create remedies beyond the bounds which the international community has trusted this court to respect in awarding damages. It is our submission that this court must continue to adjudicate disputes only in accordance with accepted and recognized principles of international law. Only this will be consonant with the consensual nature of international law. Certainly, some discretion is understood to reside in the awarding of reparations, but it is our submission only in the service of this rule and not for ends which are alien to its purpose.
Assuming we do conclude that there has been a violation of international law and a duty owed to the applicant, is there no remedy that this court could determine?
It is our submission that the most appropriate measure for this court to take would be to acknowledge that the apologetic and cooperative course of conduct exhibited by Vulpinia throughout this incident constitutes sufficient satisfaction. But, in the alternative, should this court not find that such constituted sufficient satisfaction, a declaration might be made by this court. Now, such a declaration, it is submitted, should not only acknowledge the breach, but should furthermore deem any obligation flowing to Vulpinia by this breach fulfilled by the conciliatory conduct and comport exhibited by the state throughout this incident.
But wouldn't that free all states to blithely violate their obligations with respect to Antarctica, suffering no consequences whatsoever? We would not be respecting the interests of the whole world with respect to the preservation of Antarctica and the global environment by just mouthing words and leaving it at that. There's nothing that your state has really done to correct the situation that was created by the discharge of these toxic chemicals.
It is our submission that Vulpinia does not seek to escape from having breached this obligation without any recognition of it. But it is simply our submission that this court, in seeking to regulate relations among states, must keep foremost at all times the principle of the sovereignty of states. And it is our submission that an acknowledgement by this court, or in the alternative a declaration, carries with it
What
a degree...
has the issue of sovereignty to do with responsibility?
It is simply our submission that the sovereign equality of states must always
If
be
you have
respected.
treaty obligations, they result from the sovereignty of a state, because the state is free to conclude treaties, and it has to carry out its obligations.
It is simply our submission that this court has been trusted to adjudicate disputes only in accordance with accepted principles of international law, and the accepted principle of awarding damages is to reestablish the status quo ante, and it is our submission that damages in this case cannot reestablish the disturbed equilibrium. And
But
thus,
if wrong has been done, this gives a rise to a claim, doesn't it?
it would simply be our submission that, to return to the question as well, so submitted, that a declaration by this court or the acknowledgement of the breach would carry with it a degree of political compulsion such that no supplement of damages would be required or appropriate in order to achieve the goals of deterring Vulpinia and indeed all states from engaging in potentially hazardous activities.
Well, but
Yeah,
you wouldn't object to an award of damages if there were something to be achieved by the award. Let's assume hypothetically that there was damage that we could calculate. You have admitted that there was in fact a breach, therefore, you would agree that we ought to award damages that would make the damaged party whole.
It is, and I would have to maintain my submission, that not only is there a difficulty in quantification, as we have no evidence, but there has still been no established loss to any community, not Leonia nor the community of
Well,
nations.
that's what I hoped you'd say, because what I would propose for your consideration is if our problem in establishing the correct measure of damages today is our lack of sufficient knowledge, perhaps the appropriate act for this, or award for this court to take, is to award an interim amount that might be used to study the situation, to see whether, in fact, with additional scientific investigation, we might not have sufficient evidence to take proper action that would, in fact, compensate Leonia for the damage it may have sustained. I mean, I speculate perhaps what Dr. Handlin would have learned was that the starfish were, in fact, commercially viable and valuable.
I would have to stand by my submission that this court can only adjudicate this claim on the evidence that it has before it, and simply that it is not that Vulpinia in any way disputes the laudable tenor of the movement towards environmental protection. And indeed, our good faith evidence of this is in signing the Basel Convention. But it is simply our submission that there is no foundation on which to award damages in this case. And in fact, the goal sought will be more readily achieved by having this court instead facilitate cooperative planning and commitment, absent enmity, which is necessarily inherent in a damage award.
Yeah, but you were kind to suggest that the court limit itself to a declaration.
That is my submission,
We are grateful for your suggestion, but we want to go further and to discuss the issue on substance. If damage was done to the environment, you think that no compensation is required?
It would be my submission, and I must stand by it, that no, there has been no loss sustained by any community of nations or by Leonia that is recognizable in international law. It is speculative in nature, and as such, for example, in the Schufelt and the Brouwer claims, has been held to be uncompensable.
Well, if there is an obligation, if you would admit that there is an obligation to protect the environment, damage to that environment involves responsibility. But by admission of a declaration, you admit that there has been a violation.
It is my
If you ask for a declaration, you admit that there has been something which was wrong.
And it is my submission that in many instances this court has found that a declaration constitutes full and sufficient satisfaction.
Yeah.
And it is our submission that the court should continue in that regard.
Well, these were different cases. No, it wasn't a case like this.
Well, this court has exhibited this commitment to awarding
Yeah,
damages in only clear and convincing cases by the fact it has only awarded them twice, in cases in which material damage was most demonstrable.
But that was only in cases where the court was asked to deliver a declaratory judgment. Here the applicant asked for much more than a declaratory judgment.
It is my submission that the request
Well, your
is not...
submission is different. I appreciate it.
It is simply my submission that for this court to attempt to even speculate upon that value would necessarily engage your excellencies in the consideration of loss, which is beyond what this court has ever considered. And it would be thereby relinquishing notions entrenched in the traditions and the practice of this court of awarding damages only upon demonstrable and realistic foundations. Because I see my time is running short, if I might make my final submission.
Yeah.
It is our submission.
Well, I wanted only to point out that you argue that the court had never had a case like this, but sometimes you must have the first case, otherwise you don't start case.
That is true, Your Excellency, but it is our submission that this court, even in face of such a request, should continue to adhere to the accepted and recognized principles of international law, because only then will it be consonant with the very consensual nature of international law, and the very fact that states have submitted to the jurisdiction of this court is evidence of the fact they trust this court to adjudicate disputes only in accordance with these understood and accepted principles. Should this court indeed then find that an acknowledgement of the apologetic course of conduct, or in the alternative, a limited declaration, is appropriate, the context within which the transport and the disposal took place, if I see my time is up, if I might briefly continue.
Yeah, you finished.
The context within which the transport and the disposal took place shall not escape recognition, and a strong commitment to the Antarctic environment will be exhibited. In this way, The progressive development of international law will indeed be advanced by having this court provide the framework within which Leonia and Vulpinia can together construct a regime for the future protection of the Antarctic environment, absent enmity. It is the respondent's submission that she is not responsible for any breach of right pertaining to Leonia by virtue of any rule of customary or conventional international law.
So why do you want a declaration then?
In the alternative, should Vulpinia
Alternative.
be found to have breached some right pertaining to Leonia, she is nonetheless under no obligation to provide reparations or to take remedial measures. It is our submission that this court must continue its commitment to awarding damages in only the most clear and convincing cases and to non-political and non-legislative adjudication. It is only in this way that the court can retain the respect held for it by the family of nations and be ensured their endorsement vital to its continuance. If there are no further questions, that concludes the respondent's
Thank you
submissions.
very much. We appreciate very much your esteem for the court and your interest in the prestige of the court. But we also appreciate your generosity. Well, having heard both parties, we now give some time for the rebuttal. Will you kindly use that time for a statement you wish to make?
Yes. Vulpinia seeks to exculpate itself from its responsibility and liability in this case by stating that it has no obligations under the customary law established in provisions of the Antarctic Treaty. At the 38th session of the United Nations Convention, not one state who submitted a report on the question of Antarctica took issue with the norm-creating provision of protecting the Antarctic environment. In fact, Malaysia, the leading critic of the Antarctic Treaty, called for stricter environmental controls in Antarctica. Ghana, who is also a critic, stated that there should be an environmental protection agency in the Antarctic area.
Yeah, but these are just words. Where's the practice?
Your Honor, since 1960, states who have sought to do research in Antarctica have either acceded to the treaty, been guided by the guidelines of the consultative parties, or they have abandoned their efforts in Antarctica. Clearly, there is a state practice and a recognition of that provision under customary international law. In addition,
With respect to this kind of a situation, on point, directly, the disposal of waste, the injury to a particular species, is there any practice with respect to that would support a customary international law rule that would be directly applicable here? Or are we just talking about sort of generalities of law?
no, Your Honor, under certain provisions of the conservation of the agreed measures of flora and fauna, the wildlife in the area can only be killed in order to have scientific specimens or for food for dogs or the scientific researchers in the area. And
But you refer here to customary law or to a treaty?
there is a practice in that, Your Honor. Other states...
Yeah, but practice is not enough for customary law, you know.
No, Your Honor, but there is also that norm creating...
The Convention on the Law of the Sea showed the reverse.
Your Honor, in the law in the 1982 United Nations Convention of the Law of the Sea would heavily support Leonia's position, since it is customary international law, and it is an embodiment in Article 192 and Article 194 of Principle 21, which specifically makes states responsible when activities under their control cause harm outside their national jurisdiction. And that is precisely what Antarctica is in this case. In addition, Vulpinia has admitted they breached the exchange of notes. This was not merely a political matter. The non-prejudice to the prior legal positions refers to the placement. It in no way affects the obligation they assumed when they undertook to remove those 100 drums of waste. This was registered under Article 102 of the United Nations Charter. That is that every treaty shall be registered, and that gives Leonia the right to come before this court when the treaty has been breached.
But there was an argument of estoppel.
Your Honor, Leonia would contend that this harm, first of all, was clearly foreseeable, and second of all, that they did not consent. There was no assent clearly established, which is the requirement under international law. Finally, this court, if it does not hold Vulpinia responsible and liable as it should, sends a message out to other nations that they may wreak havoc on the common heritage of mankind and destroy a species, and yet come before this court and state they have no obligation. Thank you.
No, we shall try not to send the wrong message, don't worry.
Mr. President,
Yeah.
Your Excellencies, Vulpinia is content to rely on its previous submissions. Thank you.
Well, the court has listened with great attention to your learned statements, and we are very grateful for the help you have afforded to us in trying to solve a very complicated issue, one which has arisen perhaps for the first time before this court, and we appreciated your learning and all the efforts you have placed in preparing your case, and your assistance will certainly be of great importance in our deliberations. On behalf of my colleagues, I wish to thank both parties for the contribution they've made and all the work they have done in order to present the case to the best of their abilities, or even beyond. The court will now deliberate, with your permission. Well, this court has given due consideration to the pleadings of both parties, has very seriously considered the arguments advanced by them. The testimony of it is that it has taken some time before you will hear the result. But as you know, judgment making is still a mystery. And you never know what the result might be. But we try our best, and by putting on the ropes, we try to be more human than we usually are, and try to be as objective as possible. Of course, as you know, there are two types of judges: those who render a judgment and forget about it, others who carry the judgment in their mind and for years couldn't forget that they passed the wrong judgment. But this is not your problem, it's our problem. We listened to your pleadings with great interest. We appreciated, as I said earlier, your work and your devotion to the causes you pleaded, whatever their merits may have been, and whatever the legal foundation may have been. Your devotion was honest, and this is to be appreciated. And even if a party loses a case before this court, it doesn't mean that it lost it forever. It lost it at this case. Now, we found that the applicant won the case. And the court will limit itself to this statement and reserve for itself the right to give the reasonings at a later date. At the same time, we want to point out that we found the best oralist, Mr. Cruz. He was not a winner, but he argued in a way which impressed us. And though he presented a losing case, he deserves appreciation. These are the findings of this court, which will now be translated into deeds, which are collected here, you see. And we now have to give to you, the winning team, some physical evidence of your victory. You get this? Please come forward. Well, you get this in temporary possession. You will hand it over to your successors. So to protect it carefully, because it's very valuable. It's the heritage of mankind. And you get this as a token of your victory. I give it to the lady. And what was it?
This is for the
Hmm?
This is for the
Yeah. Now, Mr. Cruz, you get this prize as the best orator. The court appreciates your modesty that you want to share it with your team. That's all right. Well, I'd be failing in my duty as judge if I wouldn't express my profound gratitude to my fellow judges who helped me and carried the main burden of these proceedings, and who, while the responsibility is mine, the merits are theirs. So that is the result of our deliberations, and we hope that you will continue the great tradition of the Philip Jessup Moot Court competition, which is a great school of learning. It's a challenge to the young generations. It is a moot court, but it's more than a moot court, because it's a fight of minds and a confrontation of thoughts, where the young have to show that the old may be wrong. And where the old control their thoughts by listening to the young. There is no better bridge invented in law than this confrontation. It is more than a university can give, because you have an immediate confrontation in cases on issues which face humanity, which face states in their everyday relations. That's why I value highly this enterprise, and I pay my respects to the American Society of International Law, and particularly the president of the society who honored us with his presence here, and to you for your great help in organizing these competitions. Now, I wish that these competitions should continue for many, many years and decades to come, in the interest of the generations of juries who will replace us here, and others will come over there. Thank you very much.
Judge Lachs, if I could take 1 minute on behalf of the society. Judge Lachs, Judge Rindskopf, Judge Charney, we very much appreciate your effort in judging the competition today. You have added the measure of finality and the right tone for the future of the competition. I think it appropriate at this time that in addition to thanking the panel, all of us should express appreciation to those who make this possible. And we all know that to be Denise Hodge and Pam Young, who've worked so hard over the past week and the many months before. And I ask you to join me in thanking them for what they've done for you and for the society.
Well, the court is, of the court is adjourned to next year.